For a long time, I personally have wanted to learn more about the court system. It's played such an important role in the history of the county. And anytime you do family history research or any kind of local research, you're going to bump into the courts and the history of the courts and how important they were. And the celebration of the 250th year seemed like an ideal time to learn a little more about it and for Judge Hupp to be the ideal person to present a program about it. Judge Hupp is a native of Shenandoah County. He and his wife Donna are friends and neighbors of mine. He practiced law in Woodstock and served 2 terms as Commonwealth's attorney and was appointed as a judge to the circuit court in 1992 and served there for 26 years until retirement in 2018. Officially, he's retired, but we know what that means. It means you're still a very busy person. As a matter of fact, he works quite a bit in the courts still. He serves on the board of the Strasburg Heritage Association. He's president of the Strasburg Museum, and he's an elder at Strasburg Christian Church. He's a student of history, particularly local history, yes, but I recently told him that I was going to see the musical Hamilton, and I felt like I needed to prepare for it so I would understand what was going on. You know, these programs, they really move fast, and you need to know what's going on if you're going to keep up with it. So he shows up at the door with a copy of an 800-page biography of Alexander Hamilton. It was pretty intimidating, but you know, I've enjoyed it. I'm not finished with it. It really did help me understand. I have to admit, I Googled the play as well, but still, it's really a very good biography, and I'm going to finish it. So now we invite Dennis Hupp to share Shenandoah County Court's history with us.
Well, good evening. I can tell you it is a privilege and a pleasure to be able to participate in our 250 celebration in this way. I am a native son, as Barbara has pointed out. I've never wanted to live anywhere else. Every branch of my family has been in Shenandoah County or one of the immediately surrounding counties since the mid-1700s. So, celebrating our 250th anniversary of the creation of our county has been a great joy to me, and I'm sure to all of you. John and Barbara Adamson both have asked me some time ago, actually about 2 years ago, to do this talk. And I told them I would do it sometime, and they would remind me from time to time, and I would say, well, I'll do it sometime. And finally, Barbara said, it's 250th anniversary. Now is the time. I am low tech. This is the first time I think I've ever given a talk where I actually have visual aids with it. And I have those visual aids because of the help of several people. Tim Taylor in Strasburg, Hank Zimmerman here tonight, Barbara, and Zach Hupp. Without their help, we wouldn't be here. And as far as my research, Barbara was very helpful in providing materials for me. And Zach Hupp, I've spent several days at the county library, and he was so helpful to me. And I can tell you something, I watched him in action while I was there in the archives room, and he is so knowledgeable, and he was so helpful to anyone and everyone who walked into the archives room. He is just a great asset to this county. I don't think he's here tonight, but if you see him, share that with him. I just think he's a real asset. 250 years. It's a lot of history. And Barbara had suggested to me that maybe 45 minutes would be a good length for the talk, and I'll have to be honest with you, I'm not sure that I can do it in that time frame. So If sometime during the course of the evening you feel the need to leave, you're not going to offend me. So just good quiet. So because of that, I think you can understand that I'm really going to give you an overview. I'm going to kind of scratch the surface. I'll share some snippets just to give you, to help tell the story. I will take the personal privilege of throwing in some of my own personal connections with some of this. Some of what I'm going to talk about will apply to the courts in the Commonwealth of Virginia at large, because Shenandoah County courts are part of that, and what happened statewide, of course, affected us here. I think the best place to start this evening is to talk about the current structure of the courts. If you go to the first slide there, Barbara.
Can you talk louder? Can you talk louder? Is it not picking him up?
No. All right, I'll try to talk into the mic, I guess, okay? I'm sorry. This is a chart giving you a scheme of our current court system. Of course, we have a Supreme Court of Virginia made up of 7 justices who are each appointed for a 12-year term. We have a Court of Appeals, an intermediate appellate court made up of 17 judges, each appointed for an 8-year term. And that is a recent change. As of this year, we have 17 judges on that court. It was 11 judges because they expanded the jurisdiction of that court. In the past, only certain types of cases were appealed to the Court of Appeals. Other cases went directly to the Supreme Court. Now, all appeals first go to the Court of Appeals, and they are appeals of right. So if you lose in the circuit court, you can take it to the Court of Appeals. You can then appeal from there to the Supreme Court, but when it gets to that stage, the Supreme Court has to grant you the appeal. It's not an appeal of right. The circuit court, there are 31 circuits in Virginia. The circuit court judges are appointed for 8-year terms. Then you have the district courts, divided into the General District Court and the Juvenile Domestic Relations District Court, which I will probably hereafter call JDR, because it's easier to say. We do have a system of magistrates who handle arrest warrants, search warrants, emergency protective orders. The judges are all appointed by the General Assembly. If there is a vacancy between sessions of the General Assembly, in the case of the Supreme Court, the Court of Appeals, and the circuit courts, the governor can make an appointment. But that person serves only until the General Assembly meets again, and then the General Assembly can either appoint that person the governor appointed or appoint somebody else. If there's a vacancy in the district court, the circuit court judges appoint someone to fill the vacancy. But again, that person serves only until the General Assembly meets again, and the General Assembly must take action. Just briefly, the General District Court has a jurisdiction of lawsuits having claims of up to $25,000, or if personal injury is involved, up to $50,000. They handle landlord-tenant disputes. They handle animal cruelty cases and dangerous animal cases. They issue protective orders. They try misdemeanors and traffic infractions. They also have some jurisdiction over felony cases, in that if a person is arrested on a felony arrest warrant, that case goes first to the General District Court, where a preliminary hearing is held to determine whether there is probable cause to believe that the person committed the crime. And if the court finds that probable cause exists, the court certifies it to the circuit court, where it goes to the grand jury for an indictment and then trial in that court. The JDR court, of course, handles what you would think of it handling: child custody and visitation cases, child and spousal support, child neglect and abuse cases, termination of parental rights, truancy. The JDR judge also hands out the driver's licenses to teenagers who have passed the test. And on a little personal note, Judge Bill Logan was the JDR judge for a number of years here, and he was well known for the talk that he gave to those young people when they got their licenses. And he was in a unique position to do that because he himself had lost a child in a traffic accident. And I went with my son David to when he got his license and heard the spiel. And I told Bill later on after I heard that, I said, now my daughter is 9 years younger than my son, but Bill, you cannot retire until you give her the same talk. And he accommodated, okay? So the JDR court handles criminal cases involving where the juvenile is a defendant or a victim, and also offenses between family members. The circuit court, where I serve and did serve, is a court of general jurisdiction. Lawsuits of no limit to the amount, injunctions, real estate, divorce, and the issues that go with it. Again, of course, child custody, visitation, support, equitable distribution of property, adoption cases, which quite frankly are my favorite cases because they're usually happy events, and also appeals from the district courts. If a case is tried in either district court, general district or JDR, the losing party has an automatic right of appeal if he or she wants to take it. And the case would then come to the circuit court where we are tried all over again as if the first trial didn't happen. We call it a trial de novo. So the circuit courts have a wide swath of jurisdictions. Circuit courts is where you find the jury trials. And let me just make one public service announcement or plea. If you're called for jury duty, please don't try to get out of it. It is so important that we have good people on juries. And I can tell you, in our jurisdiction, it's not really that burdensome. Most of our trials are one-day trials, and we're seeing more 2- and 3-day trials now than we used to. But I can tell you, in my tenure in the legal profession, which now is about 45 years, the longest trial I've ever been involved in was 7 days. It was a murder trial, capital murder trial in Winchester. So it's not like what you hear in some other states where it goes weeks and months and the juries are locked up in a motel, can't go home. It just doesn't happen here, or at least it hasn't happened here. The biggest inconvenience is that you are subject to call for a period of time, and most cases get settled and you're called off at the last minute. Only about 1.5% of the criminal cases in Virginia go to a jury trial. Most of them plead out, or are tried by the court, which is called a bench trial. Currently, Kevin Black is the judge in the circuit court here in Shenandoah County. He is my successor. Amy Tysinger is the judge in the general district court, and Chad Logan, who is the son of Bill Logan, is now the JDR court judge. Now let's go back into our history. We go to the next slide. Let me read this to you. This is an appointment of Commission of the Peace, which is basically justices of the peace in 1772. I guess that year means something to us. And I want to read from this court order. At a court held for Dunmore County at the courthouse in Woodstock, the 26th day of May, the 12th year of the reign of our sovereign Lord George III, by the grace of God, Great Britain, France, and Ireland, King and Defender of the Faith. Okay. 1772, not 4 years before the Declaration, when we were still speaking in laudatory terms about our king. Okay. And something that jumped out at me when I read this was France. Why would they put France in that? And I had to go to Zach, and Zach explained it without any hesitation. Okay. It seems that the King of England still made a claim to the crown of the King of France because of the Norman conquest. William the Conqueror, back in 1066, came over from Normandy and took over England. So from that, there was still a claim to the French crown, and there was a war fought, 100 years of war, back in the 1300s and 1400s over that very issue. And even 300 years after that, they were still claiming they had a claim to the crown of France. Anyway, it goes on to say this. I'm just listening to names to see if you can recognize any ancestors. A commission of the peace for the county and directed to Burr Harrison, Taverner Beale, Joseph Pugh, Francis Slaughter, James McCoy, Henry Nelson, Abraham Keller of the quorum. That means that those people had to sit There was a number of justices, but those of the quorum, at least one of them had to be on the panel. John Tipton, Caleb Odell, Jonathan Langton, Abraham Bowman, William Moore, George Ruddle, Jacob Holman, and Alexander Macker. Tabner Bill was appointed High Sheriff, and Thomas Marshall was the clerk of the court. Thomas Marshall was the father of Chief Justice John Marshall, the famous Chief Justice John Marshall of the United States Supreme Court. And Archibald Ruddle, one of my grandfathers, my sister Sally's grandfather, was appointed constable. Okay. Recognize any family names that I have two or three others that are familiar. So that was the original justices of the peace for Shenandoah County. An order was entered in 1774 that the house of Jonathan Langdon be prepared for a courthouse. And commissioners were appointed to buy land for the courthouse. You go to the next one, Barbara. This is the Dick Wickham House at the end of Warriors Row. And it served as an original courthouse. I think the log structure that was originally there is gone, but this served as a courthouse thereafter for I guess 2 decades. So there's another picture from another angle. So again, we know it as the Dick Wickham House. I think the Woodstock Museum now owns it, at least the placard says that anyway, and so it was the site of the original courthouse. Then there's an order for the courthouse in 1795. I'm going to read this to you because, well, I'll tell you why in a moment. 16th day of May in 1795, ordered that a courthouse be built on the public lot in Woodstock in front of the present one, agreeable to a plan furnished at the January court last of stone and brick with this amendment, that it shall be 25 feet in the clear at the end, the back side of the courtroom to be left to the commissioners to be made as will be most proper, the foundations of the same to be 2.5 feet thick, 18 inches high from the ground to the first set of joists or sleepers, the first story 13 feet high, clear of joists, at least 2 feet thick with 6 inches in front and 5 back, of 24 lights, window panes, each of 8 by 10 inches, the frames of which to be made of good white oak, worked out of the solid with a place for fixing weights to hoist the sash, with the necessary doors, and the second story to be 9 feet clear of joist, the wall at least 18 inches thick, 7 windows in front and 6 back, of 20 lights each, the frames to be made of good white oak and to be worked out of the solid, and 1 door to each of the rooms above, to be covered with the joist shingles of chestnut. A steeple to be built on the house, and that the partition walls, which are to be made of brick, be made so strong as to bear the said tent steeple. The front to be ranged work, a pediment to the courtroom, and the mortar for the mason work to be made entirely of sand and lime. Now you're talking about micromanaging. My wife accuses me of this about all the time. I'm a micromanager. So, honey, it goes with the profession. If we could go back then to the second slide. Okay. Look what I have. My wife bought this for me years ago for Christmas, and I took it out of the package today. As I told you, I've never used visual aids before. Just the progression of the courthouse, of course, the original structure. This middle structure was built in 1871. It's where the courtroom is today in the building. And then in 1886, this back section was built as a clerk's office. And it functioned as a clerk's office. Where the court functioned there as a circuit court until the current circuit court building was built in its 1970s. We go to the weather vane. I'll give it a little bit. this is the weather vane that on top of the courthouse, and there's been I guess, a debate for years as to what it is. Everybody knows an Indian for years. I can still remember hearing the guys over at the Walton Street Drugstore, the coffee club, wanting to see which way the Indian was pointing so they could predict the weather for the day. But it turns out it's probably some sort of soldier. There's been suggested it's a member of the Swiss Guard. And that's curious to me because the Swiss Guard, the real Swiss Guard, is appointed to the Vatican to protect the Pope. And back in that day and age, Catholicism was not held in high regard in this area by the people here. And that's not a comment from me now, please. I mean, that's just the way it was. But anyway, another picture in full color. Anyway, it's part of the history of the courthouse. There was a bell added to the courthouse in 1809 or later. We know it was cast in 1809, so we know that's when that happened. So, progression, 1795, the original courthouse structure built. 1871, the next section built, and then the last section in 1886. And in 1927, the columns on the front were added to the courthouse. Back in the colonial days and the early days of our independence, the justices of the peace handled minor crimes. They tried minor crimes. They handled property disputes, small claims. They probated wills. They settled estates. They appointed guardians for children. And I guess it's a curious thing to us today, but even when the mother was still alive, if the father died, the court would appoint a guardian for the children, different age. But anyway, of course, if the children had no parents, then they were often bound out to artisans or tradesmen so they could learn a trade. I even found one case where the loser in an election was contesting the election. Imagine that. Another interesting thing is many times the payments, whether of the court order payments or the compensation to different officials, was paid in tobacco, even here in Shenandoah Valley, or in hemp. So, as we know, tobacco kind of gave way to small grains. Wheat became the cash crop, and we left tobacco behind. But a hogshead of tobacco was equivalent to about 63 gallons. That measurement was really designed for a liquid measure, but they used that term for the tobacco as well, a hogshead, 63 gallons, and it weighed hundreds of pounds. That term comes from an Old English word, hoggus heave, and can't promise you I'm pronouncing it correctly, but it was again designed for really measuring the quantity of beer and liquor, but anyway, they used it for the tobacco as well. As far as criminal sentences, of course, there was always jail time. There were fines, often paid in tobacco or hemp, and also lashes, whipping. I did not find any reference to stocks. So, in Williamsburg, you go to Williamsburg and take a picture of the stocks. I found no reference to that. Major crimes, the justices of the peace would hear evidence to determine whether there was enough evidence to hold the person over for trial in the general court. You want to guess where the general court was in the colonial days? Williamsburg. And after independence, Richmond. So the poor defendant had a long wait until he or she could be tried. The other thing that I found interesting in my research was the number of cases in our court involving slaves. Now, we have always thought, at least, that slavery wasn't that prominent here in the valley, and indeed it wasn't nearly as prevalent as it was east of the Blue Ridge. But we had slavery, and we had slaves. And there were a number of cases, slaves suing for their freedom. Oftentimes, these slaves were indentured servants. They'd be people who contracted with someone to serve them for a certain number of years, and then they would be free. And I suppose the issue was, time's up, I want to be free, and maybe the quote-unquote owner was objecting, I don't know. But also, genuine slaves would also be sued for freedom from time to time. There were cases where the slave brought a suit alleging they'd been cruelly treated, which was really interesting to me. They had that right of redress back in that day and age. Of course, you had cases involving runaway slaves and suits to recover slaves. We had, of course, crimes committed by slaves were handled in a different way. The court became a court of oyer and terminer. It was designed to just handle slave cases where slaves have committed a crime. The minor crimes that court could try and decide. Major ones, again, went to the general court, either Williamsburg or Richmond. Another thing I found interesting was I found with Zach's help a manual like that, kind of like the Hamilton biography, but written by a man by Mayo. It was a manual to give direction to the justices of the peace and the clerks of the court on how to handle things. And this is in 1850, and part of the procedure in a slave case was to appoint an attorney to represent the slave. So again, I guess it was surprising to me that they had that much consideration for their, I'll call it, for the rights, if I can use that term. I am going to share a story about one case. This is set out in Fred Painter's book, Shenandoah County Courthouse. He thought it was worthy to devote a chapter to it, and I think it is because it paints a picture that I think we need to see. The story was there was a girl who was light-complected. I'm going to say Negro because the case is called Negro Sarah versus William Guthrie. It's the term they used at the time, and that's why I'm using that term. Turns out her grandfather was white, and she lived with her aunt, who was also a light-skinned Negro. Mulatto was the term. And the aunt, from the court order, it appeared she was married to Thomas Delaney. Now, that was surprising to me because miscegenation, interracial marriage, I thought would have been illegal. In fact, it was illegal in Virginia until 1967, when the United States Supreme Court, in the case of Loving versus Virginia, ruled that our law was unconstitutional. And there's a movie made about that case, Loving versus Virginia. So anyway, she may have just been his consort. Okay? But anyway, he took the girl who was 8 to 10 years old at the time, and they kind of vanished from the area for a while. It turns out that he did sell her. Now she maintained that she was free, had always been free. Her aunt maintained that she was free and had always been free. The court gives a detailed recitation of the evidence in the case, talks about how the aunt pleaded with Thomas Delaney not to sell her, talked about how the girl was torn from her aunt's arms, sobbing and wailing. It's just heartbreaking. And this is what the court said about Thomas Delaney. It said he is in want of necessaries and seemed as if he should go to almost any lengths to get liquor, of which he was very fond. So anyway, it turns out that he sold her, that person sold her again, and all the time she was claiming to be free and went through several owners. And in the court case, she brought a suit to prove that she was a free woman by this point. And she brought in witnesses, produced reputation evidence. That is, yeah, we always knew her to be free. That type of evidence. And finally, the court ruled she was indeed free, but she was compelled to get there. Shame, shame, shame. Ugly part of our history. Ugly part of our history. The courts also had what we would consider executive powers. A lot of executive powers, even though we had adopted in the United States Constitution and even the Virginia Constitution the separation of powers. The local courts, the justices of the peace, appointed overseers to maintain the roads, overseers of the poor. They granted licenses to operate a ferry. They also granted a license to construct a dam and would have a court hearing about the effect of the dam on the neighboring property owners. They granted licenses to sell liquor. They maintained the tax list. They appointed the county surveyor. They actually appointed food inspectors for pork and beef, and also for tobacco. They appointed the church trustees and also ministers to conduct marriages. Now, in those last two regards, let me say we still do that, okay? On church trustees, the circuit court still appoints the trustees. Now, it's pro forma, you appoint, now the church says they want to appoint it, but anyway, it has to be appointed by the circuit court. And also, we're the ones who have to authorize marriage officials, whether the ministers or somebody else, to conduct marriages. The circuit court still appoints the electoral board, the board of zoning appeals. And until 1993, the circuit court appointed a school commissioners, who in turn appointed the school board until that recent time. I meant to point out a little while ago some of the types of cases that the grand jury returned back in 1784, just to give you an idea of what they were dealing with. 6 cases for selling liquor without a license, 2 for not maintaining roads, 5 for not paying taxes, 5 for not paying your tithes. You know that the Church of England was the official church in Virginia until Virginia adopted Thomas Jefferson's Statute of Religious Freedom in 1786. So until then, you were required to pay tithes to what became the Episcopal Church. Maybe Episcopalians in here would like to go back in this system. So there are some of the types of cases that these justices were hearing. In 1830, the General Assembly created a superior court of law and chancery for each county. Now, law and chancery, I don't know whether that means anything to you, but so I'll explain it. Okay. I think you all know that we have adopted the common law of England, and that's where we get our common law system. And the way the common law works is, as courts make decisions, as time goes on, we look back to those decisions and stick to those decisions to the extent possible. It's a doctrine we call stare decisis, stand by the decision. So what happens is, as the courts, appellate courts, make decisions, they really are creating law as well, because the courts then look back to that decision and try to follow those decisions. So that's the common law system, and we still have it. One of the first statutes in the Code of Virginia adopts the common law of England, and of course we've taken it from there in our own system. But back in England, some cases just did not have an adequate remedy of law. The law just didn't come up with something that would satisfy the litigants. So they created chancery courts. And chancery courts were designed simply to do the right thing, to do equity. And so they had a court of law, a court of chancery. Well, then, of course, those two functions got combined in this court of law and chancery. So the same court would hear the cases, law and chancery. That division stayed with us until 2006. Back before 2006, if you filed a lawsuit in circuit court, you either filed it at law or you filed it in chancery. But then in 2006, we merged the two, and now when you file, it's just a civil action. It's not an action at law or a suit in chancery. 1830. 1851, Virginia adopted a new constitution. With that, it abolished the general court. It created circuit courts. It also established county courts that were required to meet at least once a month. Sometimes they were called monthly courts. And on court day, it was a big to-do. People would come from miles around to watch court, to visit with their neighbors, conduct business, picnics, all kinds of things. It was a big day on court day. The 1851 Constitution also provided for the popular election of judges. Now, let me make a comment about that. Most states in this country have popular election of judges. There are only 7 states in this country that do not elect any judges. That is, have a popular election of any judges. Virginia being one of them. And I have a lot of problems with that system. It's hard for me to imagine that a judge can do his job, that is, be independent and decide a case based on the law and evidence before him, while wondering how his decision, or her decision, is going to play with the electorate at the next election. But apparently it works across the country because most states do it that way. We do not. The General Assembly elects the judges, and I think it's a better way of doing it. South Carolina is the only other state that does it the same way we do. The 1851 Constitution did take away some appointive powers of the justices. 1861. Judge Greenberry Samuels, I believe, was the presiding judge, and at this order, he was clairvoyant, I think, could see what was coming. It appearing to the court that the uneasiness of the times required the removal of the public records of this county to some place of safety, it is therefore ordered that the clerk of this court remove to some safe place, or places in or out of the county, such as said records as to him may seem proper, and that he be authorized to employ suitable persons to execute this order. Order that the books and papers belonging to the court of this county be returned as soon as the clerk may think they can be kept safely in the office, and that the clerk be appointed to attend to the same. Our records were preserved. Rockingham County was not so fortunate. They tried to do the same thing, but the wagon that was bearing the court records was overtaken by General David Hunter's troops at Grottos, and the wagon was set on fire. David Hunter was a Virginian who turned his back on his native state, no say, but anyway. Fortunately, the fire kind of worked in a C fashion, so the outer parts of the documents were burned, but the core of the documents, a lot of them were preserved. And they still have those books in the Rockingham County Courthouse. So they were able to preserve most of the records. You can imagine the chaos in the land records that would cause if you lost all your deed books. We know that the armies were up and down this valley all 4 years of the war. They were in and around the courthouse repeatedly. We go to the graffiti. And some of the soldiers left their mark. This is in the upstairs of the courthouse. There's graffiti written on the walls, and we believe there's a graffiti over all the walls, but only certain patches have been revealed. I like to think the Yankees did it, but I think there's some Confederate scribbling there too. But anyway, there's three images here. It's hard to really read it here, but it's just an indication of what's there, and it's actually something we want to preserve. It's certainly part of our history, and I know Barbara's been very actively involved in helping to preserve that. Barbara, I wanted to ask you, can people go look at the graffiti? Or?
Sure. We're just open Fridays and Saturdays, but we're happy to help folks go upstairs and look at it.
Right.
Yes.
Courthouse is open on Fridays and Saturdays, and you can go up and look at the graffiti. There are a lot of steps to go up, but it's well worth your time to look at it, because it's just part of our history, and if you can actually decipher some of it's pretty interesting, some of it's kind of funny. And I think maybe some of it's a little bawdy, but anyway, imagine that. The court also entered an order to appoint commissioners so that the county could borrow money to get through the war. And then I want to read this to you because it really gives you a description of what was going on. This is an order from the court. It appearing to the court that the uneasiness of the times, the county court of Shenandoah not being able to meet at its usual place of session since the Monday before the second Tuesday in September last, in consequence of the occupation and threatened invasion of the county by the public enemy. Now in session at Mount Jackson in said county, under the notice issued by virtue of a recent act of assembly, authorized a change of the place of holding that's the same, certify first that a vast amount of grain and forage has been burned in the county, and that quantities of stock of all kinds have been destroyed or driven off by the public enemy. A very large proportion of the mills, barns, and many dwelling houses have been consumed. We have not had an opportunity to ascertain precise amount of the distribution, but are satisfied that a large portion of the county is almost entirely destitute of supplies, and that in the residue there is not sufficiency for the population resident therein. So great is the so great is the destitution, that the court deems it necessary at their turn to make arrangements for the procurement of supplies issued here in the county. The grain and forage left is very unequally distributed, and this will promote the greatest suffering imaginable. These will all be necessary to procure and distribute supplies of food, forage, wood, etc., and give adequate care and protection to the families with which they are connected, the families of soldiers and others who are destitute. The stock necessary to be kept on hand for agricultural and other purposes also required the presence of these men to secure it from the public enemy and to feed and house them. That is, took soldiers away from the army to do these things. That the court regrets the necessity of urgency of this appeal, but feel to be more free to make it in view of the suffering and sacrifices of the people of this county during the existing war. They have withheld nothing, either in men or supplies, from the public service which it has been in their power to furnish. They have never been disposed to trouble or annoy the authorities with complaints. The period has now arrived, however, in this when the highest sense of public duty impels this action on our part, in consideration of the public interest, and the court trusts and hopes that the prayer of this memorial and the representations of their agents selected to bring these matters more fully to the attention of the proper authorities will be respectfully heard, duly considered, and favorably answered with as little delay as practical. It's ordered that S.P. Rupert is appointed general agent for the county of Shenandoah to purchase supplies of corn and wheat for the support of the families of the soldiers and others who have been rendered destitute by depredations of the public enemy. And he goes on to appoint agents throughout the county to gather food and supplies to keep people alive during this time. And it was 1864, the burning winter was coming on. War is over. In 1867 and 1868, the Congress passed the Reconstruction Acts. And the Reconstruction Acts converted the former states of Confederacy into military districts. Virginia was military district number 1. And General Schofield of the Union Army was put in command here in Virginia. Reconstruction Acts required the southern states to adopt new constitutions, largely guaranteeing the rights of their black citizens. And they had to adopt these constitutions and have them approved by Congress in order to be readmitted to the Union. So in 1868, Virginia had a constitutional convention where a new constitution was enacted. It did provide for the protection of the rights of black citizens, provide for constitutional officers, which is a system we still have today. It brought back the appointment of judges by the General Assembly and not popular election. It's often called the Underwood Constitution because Judge John Underwood presided over the Constitutional Convention. In Virginia, then, part of what the proposal, what the Congress wanted the Constitution to do was to prevent former Confederate leaders from holding public office. There was a great objection to that in Virginia, as you can well imagine. They separated those provisions out. They were defeated. But President Grant and the Congress accepted Virginia's Constitution even without those provisions, so the former Confederate leaders could again hold office. And of course, let's face it, they were the people who led the state beforehand. It made sense to have them back in charge again. Maybe reluctantly observing the rights of the black citizens, and of course that did change later in the 1902 Constitution. A lot of those things were rolled back once the old guard was back in power. In 1902, new Constitution, as I just mentioned, circuit courts remained. They abolished the county courts, but replaced it with a system of trial justices. And that was our system for the lower, for the minor cases and the things that the justices of the peace heard before. We now had trial justices, and they would have county trial justices, and also each incorporated town had a municipal court with a trial justice. And that was the system until the early 1970s. We were in the 17th Circuit, made up of Shenandoah, Warren, Clark, Winchester, and Frederick counties. In 1970, we rewrote our Constitution again. And that brought about our current system that I've already gone over with you. We are now part of the 26th Judicial Circuit. And it's the same counties and jurisdictions that I've just named, but Rockingham and Page were added to our circuit. So they are now part of the 26th Circuit. We can go to the next. Obviously, courthouse that we know. The next one's in Fort Cole. It is a trash room. It is a trash room. And it is still used for court functions. We use it now as an overflow courtroom when we may have two judges here at the same time in the circuit court. It was used by the bankruptcy court for a while. Once the circuit court, that's the red brick courthouse, okay, across the street from the old courthouse, was built, this building was the courthouse for the district courts until the new district court building was built in 2013. So again, we've maintained the distinction of having the oldest courthouse west of the Blue Ridge Mountains still in active use in the entire country. Picture of Warriors Road. Well, excuse me, I forgot about this picture. This is the interior of the old courthouse in the original part, kind of a refurbished courtroom, kind of what we thought it might look like. This is Warriors Road, beside the courthouse. Miles with the practice walls upstairs in that little brick building, the French building. This is the circuit court that you know today. It was built in 1975, but it was not occupied until 1977. Why? Because there were structural problems with the courthouse. You all might remember all this. Monroe Janney, who was a foreman on the project, refused to go back in the courthouse after it was built because he thought it was going to fall down. That's what he said anyway. They had to go into the courthouse, into the attic, and do weights to counterbalance the walls to keep them from collapsing. And even today, if you go into the courthouse, in the law library and in the courtroom, there's a molding strip in the corners. And if you take those molding strips down, there's a crack between the interior wall and the exterior wall about that big, about 2 inches. But it's still standing, and we still use it. I started practicing law in 1977. So I was in the kind of the first group to use this courthouse. And I remember the first day that we were holding court, Judge Elliott Marshall was the judge, and some of us gathered together because we thought he would have some fine words to say about the courthouse. He didn't say a damn thing. he went straight to the first case and kept on going. The next slide is the new district court building, built in 2013. This is for the district courts, the general district court and the JDR court. It is a very nice structure, and it meets their needs extremely well. Let's go to the judges. This is Greenberry Sanders. He was the circuit judge here in Shenandoah County in the mid-1800s. believe beginning in 1851 with this new Constitution. Point of personal privilege, Greenberry Samuel's son served in the same company of the 10th Virginia that my grandfather served in. And when I say my grandfather, I'm talking about my mother's father, okay? So there's a letter that he wrote home after the Battle of Gettysburg where he talked about the men in his unit who had been wounded, and my grandfather was one of them. So we know good authority that he was wounded at Gettysburg. He did survive the war, of course. I mean, Blair Circle asked me that one time if he survived the war. I said, Blair, he was my grandfather. Really? He was born in 1840. My mother was born in 1908, so he was 68 when she was born. Of course, his wife is 29 years younger than he was. She was the 11th of 11 kids born over a course of 18 years. Anyway, personal privilege. Greenberry Samuel's son served in the same unit as my grandfather. Another connection. The next one is Robert Height Turner. He was from Front Royal, from Warren County, but was assigned to serve here primarily in Shenandoah County, and I don't know a lot about him beyond that, so I can't say much. The next one, T.H.C. Whiting, was from Winchester, also served in our court. Once again, I don't know a lot about him. The initial of THC today, I think I probably would change it, but anyway. That's the chemical ingredient marijuana, by the way, okay? All right, next is Burr Harrison. Remember the list of original justices of the peace that I read a while ago? One of them was Burr Harrison. And this is not the same guy, of course, but obviously his family had a long-standing relationship with Shenandoah County. So this is Burr Harrison. Next, Philip Williams. Now, Philip Williams, he was Philip Williams III, and he was actually from Winchester. And the interesting story about this was, and we'll get to Perry Sarver after a while, we got to Perry Sarver appointed circuit court judge in 1983. And one of the arguments we made to the General Assembly that it was that it was our turn. We said that Shenandoah County hadn't had a resident judge since Philip Williams. Well, we were wrong. This is not we had confused him with his grandfather, Philip Williams II, who was born in 1802 in Woodstock, served as Commonwealth's attorney in Shenandoah County, served as clerk of court, and represented us in the House of Delegates. So our history was wrong. So it turns out that Perry Sarver was the first resident judge from Shenandoah County since Greenberry Samuels back in the mid-1850s. So it was our turn. Next, Burr Harrison. This is another Burr Harrison. This is the grandson of the judge I just showed you. Burr Harrison was also from Winchester. He was appointed in 1942 and served until 1946. I meant to mention his grandfather, Burr Harrison, was a World War I veteran and actually served in the Army Air Corps. I thought that was interesting. So come back now to Burr Harrison. Served from 1942 to 1946. He decided then to run for Congress. He was elected to Congress and served in 1962. In 1962, our favorite son, Jack Marsh, was elected to take his place. Next judge is Elliot Marshall. Now, I can't say enough about Elliot Marshall. He took the bench in 1947, served until 1974. But his successor, Duncan Gibb, developed cancer and was off the bench for long periods of time. Judge Marshall came back to serve in his place. And that's how I had my exposure to Judge Marshall. Judge Marshall was an institution. We often said he forgot more law than most of us had ever met him. And he could scare the hell out of you. He had a scowl that would make you tremble. And I only saw him laugh in the courtroom one time. And he was laughing at me. And the argument that I was making. Once he knew the attorney and knew how the attorney conducted himself or herself, at that time I guess it was all himself. But anyway, he would, if you took an order into him, he'd flip to the last page, sign it, and hand it back to you, and say, well, if you messed it up, it's on you, not me. But anyway, when you first started practicing law, when I first started practicing law, he would take my orders and he would read them very carefully before he signed them. And so about the fourth or fifth time I went in with an order, and and he flipped to the last page and signed that order. I felt like I graduated from law school. When I took the bench, the day before my investiture, I went down and took Judge Marshall to lunch. He was retired and living in Westminster, Canterbury, in Winchester. And we had a great conversation. He told me stories, and we talked about what he really wanted his advice. And we got ready to leave. I said, well, Judge Marshall, is there any other advice, pearl of wisdom you can give me before I leave? He said, yeah. He says, when you gotta go, take a recess. It's bad on your bladder otherwise. Duncan Gibbs succeeded Judge Marshall. He was a member of the House of Delegates, became a judge, served until 1980. Again, he was off the bench for a good part of the time. A very distinguished gentleman. Next is Judge Whiting. Henry Whiting was from Winchester. He served from 1980 to 1983. Judge Whiting was in his law office every day about 5 o'clock in the morning. So if you wanted to call him, you could get him there between 5 and the time court started. When he became a judge, he kind of thought he was going to continue that same pace. And he would set cases not at 5, but like at 7:30 in the morning. You know? And there was enough grumbling among the bar that finally he backed off of that. He was quite a worker. In 1983, he was appointed to the Virginia Supreme Court and served there for a number of years. Harris Harper. Perry was my law partner. When I came out of law school, I joined Perry in the practice of law. We formed a partnership, and I then followed him onto the bench. He served until 1996. I was appointed in 1992, but my duty stations at first were Warren County and Harrisonburg. And then after 4 years, when he retired, I was brought back to Shenandoah County. I primarily had Shenandoah County and Warren County. Back then, we had 5 circuit judges, not 8. They recently added the 3 additional judges. We had gotten to the point that we were overwhelmed. And the General Assembly finally answered our call and gave us help. 3 years on top of our 5. And we were working on these pictures when I was working with Tim Taylor on these pictures. He asked me, he said, well, who was the longest serving judge in Shenandoah County? I said, well, I got to think about it. It's me. Tedder Block is now taking my place on the Circuit Court bench. During this time, you all might remember Richard Wright or Colonel Racy. They served as trial justices, not in the Circuit Court, but as trial justices in what I would still call the county court. Now, whenever you have a judge or attorney talking about the courts and the history of the courts, you're going to get some what we call war stories, and I've got a bunch of them. I think you'll enjoy some of this, okay? This is a story that I was told when I first started practicing law, and I think Perry is the one that told me. And he swore it was true. He was a very well-known attorney in Shenandoah County. I'm not going to say his name in this instance, but anyway, this is back in the 1950s. He was representing a man who had stolen the hog, and his fee was half the hog. So in his closing argument to the jury, he said, members of the jury, I'll tell you one thing, my client has no more of that hog than I have. Another case, this has been shared with me by Kermit Lee Racy, who I think got it from his father. Moonshine case. A guy by the name of Buck Green. I don't know whether I hope I don't embarrass anybody, but he was a well-known moonshiner. He was charged with, of course, manufacturing and possessing illegal alcohol, and he went to court, and the judge found him not guilty. And once the verdict was announced, Buck said, "Well, Judge, does that mean I'm going to have my moonshine back?" I had a similar situation. I was a commerce attorney at the time. We had a defendant in district court before Judge Racy, and he was charged with stealing a car. So we went through the process of appointing an attorney for him and setting the court date. And right before we got ready to leave, Judge Racy said, "Wait a minute, there's a charge here of expired tags." And with that, the defendant said, "Don't know nothing about that, Judge. They were on there when I stole them." case when I was representing a boy in Newmarket, from Newmarket. He was charged with driving suspended. And what he said, told me is that his car was parked in the street. He was told he had to move his car, so he's moved it right down the street to a parking lot. But when he did it, by his luck, Deputy Sheriff was driving by that knew he was suspended, arrested. So by the time we got to court, he'd been in jail about 7 days. Judge Allen, Bill Allen was a substitute judge, and he was sitting that day. And I put more on the stand, but this is a pretty good, reasonable explanation. I think maybe the judge would go light on him. So anyway, I put him on the stand, and we got done testifying. He said, well, I think you've served your time, you can go. But Billy Logan was the Commonwealth's attorney. He said, wait a minute, Judge, aren't you going to fine him? And Judge Allen said, well, Mr. Logan, this boy doesn't have any money. He looked at my client and said, that's right, son, you don't have any money, do you? My client said, no, Judge, but we'll have in 2 weeks. So Judge Allen said, well, in that case, I fine you $25. Well, way out of the courthouse, I told my client, there's a difference between telling the truth and volunteering information. Billy Logan reminded me of this story. He was Commonwealth's attorney, and he was trying, I'm going to use the name because it was a well-known case. He was trying Ruby Wetzel for murder. She had poisoned her boyfriend. And Ruby was on the stand in her own defense, and one of the ways you can impeach a witness, that is, attack the witness's credibility, is to show that the witness has a prior criminal history. So Billy asked her, said, well, Miss Wetzel, is it true that you've been convicted of prostitution? And Ruby said, yes, and it was a damn good one, too. In court again with Judge Allen. This is during a time when the JDR court was meeting in the French building, because I think the old courthouse was being refurbished. After the circuit court moved, they had to refurbish the what we call the old courthouse, our historic courthouse, for use by the district courts. So he was sitting over in French building. It was obviously not a very not much decorum there, because he was sitting there on a folding table and the people almost were standing over him. But anyway, a man comes in and Judge Allen says, well, you're charged here without paying your child support, without paying your child support. And the man said, well, Judge, how much is it? And Judge Allen told me, in a real cocky fashion, he reached in his pocket and pulled out a great big wad of bills and counted it out and said, there, it's paid. Judge Allen said, that's great, thank you, that's very good. Can you reach in your other pocket and pull out 30 days in jail? Child custody cases are probably the hardest cases I hear. But sometimes they give you some levity, okay? When I can, in agreement with the attorneys and the parties, if I can in a child custody case, I take the child into chambers and talk to the child by myself, because having them testify in front of the parents just adds to the trauma we're already going through. So anyway, I had one little boy, brought him back and set him down and talked to him. He looked at me and said, why do you wear your hair like that? And I said, because that's the way my daddy wore his. Another one, a boy and a girl, brother and sister, went to talk to him. I brought the boy back first and talked to him for a while. And at the end of it, I said, well, is there anything else you want to tell me? He said, yeah, the creek's flooded, I can't get across. So I thought, well, maybe this is the way they get in and out of the property. I don't know why. So I was asking, so why do you want to cross the creek? He stared at me for a couple of seconds and he said, to get to the other side. Well, that explains the chicken in the road. So at the end of my conversation with him, I said, well, would you send your sister back? And he got this funniest expression on his face. His eyes got real big. I said, I don't mean send her back where she came from. I mean send her back to talk to me. And there for a while he thought, this is good, too good to be true. I should have come in a lot sooner. When I was college attorney, I was prosecuting a case for murder. And the defense was insanity. And he had an expert, Dr. Eloise Hall, she was his expert, and she found that he was insane at the time of the murder. My expert was Dr. Centaur, who worked at Center State Hospital in Petersburg, and he had found that the defendant was sane at the time of the murder. So in preparation for the trial, I had to go to Petersburg, to the Central State Hospital to talk to my witness. And Central State Hospital is a secure facility. You go through one door after another until you finally get to a little conference room. Dr. Cinto comes in telling me about the test that he administered to determine the boy was sane. And he said, well, I administered the Rorschach test. That's the ink blot test. Okay. So what I did is I gave you an example. He took one of the slides and threw it out in front of me and said, now someone who is sadistic or has violent tendencies or maybe is antisocial would look at that and see a cat that's been run over in the road. That's what I thought it was. I thought, I'm not going to tell him what I'm thinking because he'll never let me out of here. One last story. And Orrin Fritz was here. I let him tell it because he'd love to tell it. Early in my practice, early on, you take anything that walks in the door. You try to make a living. And so Orrin took this case because he enjoyed these type of cases. But anyway, a girl and boy who lived together. And she was suing him, they separated, and she was suing him for his half of the phone bill. So Orrin represented the girl, I represented the boy. So Orrin put on this case, and Judge Harold Potch from Clark County was presiding. And at the end of Orrin's case, he said, well, I'm going to award $50. And I said, well, wait a minute, Judge, I haven't put on my case yet. And he said, oh, that's right, Mr. Hupp, I'm sorry, go ahead. I put on my case. He gave her $90. Orrin enjoyed telling that story. One last story, this is a poignant one, really. Had a case, two sisters arguing with the brother over the care of the mother. The story again, the two sisters pretty much took care of the mother up until recently before a court case. And the brother came in, took her to his house, the power of attorney got changed, the will got changed, you know the story. Okay. Anyway, they were fighting. And I don't remember, we must have gotten started late in the day of the case because it was at 10 o'clock at night and we were still going. And while they were arguing with each other, the bailiff came up and handed me a note. And I had to tell him that while you all in this courtroom squabbling, your mother has passed away. And it was just a sad, sad thing. And it just, money can bring up worse. I'm ready to stop. Let me just a couple of final comments. Lawyers oftentimes get a bad reputation. I'm a lawyer judge that I enjoy like anybody else. And like any other segment of society, there are good ones and bad ones. But in my experience, practicing law, serving as college attorney, judge, and now I continue to serve as a substitute judge in 45 years. I can say that most attorneys are honorable and trustworthy. And I'm proud to be part of that profession. I'm also proud to be part of the judiciary. We don't always get it right. There are glitches, there are failings, there are flaws. It is, after all, a human institution. But I think people are well served throughout our country by our system of justice. I mean, the judges across this nation recently stood firm against a massive assault on our republic. I think Virginia in particular, I guess it's something like tooting my own horn, I really think we have an excellent tradition. And again, proud to be part of it. It's been a great privilege to be part of it. And I suppose next to the honor and privilege I have of being married to my wife Donna, who has been so supportive through these years, the highest honor and privilege that I could have hoped for in my life is to be a judge, part of the judiciary. And during that time, I can tell you that almost every day I pray for wisdom. And I try to never lose sight of how my decisions affected people in some very real and personal ways. The next slide. This is a plaque that's at the front door of the Supreme Court of Virginia in Richmond. And you can see it reads, this is a quote from Chief Justice John Marshall. The judicial department comes home in its effects to every man's fireside It passes on his property, his reputation, his life, his all. And I would hope that every judge would take that to heart. And perhaps we all ought to pray from time to time, invoking the words of the ancient prophet Amos, that justice will roll down like waters and righteousness like an ever-flowing stream. Thank you for listening.